On the last day of term, the Supreme Court's 6 conservatives struck a blow for parental rights. No, they're not going to let parents decide health care for their kids. Don't be silly. They're still going to let states ban gender-affirming care for minors. Instead, they've allowed parents to ensure that their children are never exposed to dangerous books like Uncle Bobby's Wedding, Pride Puppy, and My Rainbow, because some religions say LGBTQ+ people are bad, and so it's unconstitutional for teachers to, quote, normalize them by reading picture books that show gay people living happy lives where they're loved and accepted by their families. What's the difference between exposure and coercion? Do rainbow puppies equal radical indoctrination? And what is in Justice Neil Gorsuch's browser history?
That's the one where they are supposed to look for the leather and things and bondage, things like that.
It's not bondage. It's a woman in a leather.
Sex worker, right?
No.
No?
It's not.
Sir, this is a Wendy's? Montgomery County, Maryland is one of the most diverse counties in the nation. It's also one of the most educated and affluent, and its public schools are excellent. For the 2022-23 school year, the Montgomery County Public School System introduced into its pre-K through 12th grade language arts curriculum several storybooks featuring lesbian, gay, bisexual, transgender, and queer characters. The books were added as part of MCPS's commitment to providing a culturally responsive curriculum that promotes equity, respect, and civility. It was the affirmative belief of the school board that representation in the curriculum creates and normalizes a fully inclusive environment for all students and supports a student's ability to empathize, connect, and collaborate with diverse peers and encourages respect for all. So when people accuse the school of trying to normalize LGBTQ+ people, they are right. MCPS set out to ensure that all students would be exposed to books about gay and trans people who make up roughly 9% of the US population. Gay kids could see themselves represented in stories like Prince and Knight and Love, Violet. Trans kids would see themselves in books like Born Ready and My Rainbow, and everyone could enjoy a fun picture book about a puppy at a pride parade. Initially, the school provided an informal opt-out for parents who objected to the books on religious grounds. But MCPS says that became unworkable, and many of the parents seeking to opt their children out did not cite a religious objection, but instead expressed their moral opposition to gay marriage or their personal belief that kindergartners were too young to learn about pride. And that's not the same thing. MCPS says that the growing number of opt-out requests gave rise to 3 related concerns: high student absenteeism, the infeasibility of administering opt-outs across classrooms and schools, and the risk of exposing students who believe the storybooks represent them and their families to social stigma and isolation. That is, if your kid who's trans or gay and half your class walks out the day the teacher reads a book about kids like you, it's inherently stigmatizing. And so the school discontinued the opt-out policy. In May of 2023, 3 sets of parents sued in the district court in Maryland. They accused the school system of introducing pre-K and elementary school kids to certain books that promote one-sided transgender ideology, encourage gender transitioning, and focus excessively on romantic infatuation. They pointed out that the county provides opt-outs for sex ed and from activities like Christmas carols or Halloween parades if parents object, and they said that stories about pride parades are the same thing. They claimed that the lack of an opt-out violated the First Amendment's free exercise clause, as well as the parents' due process rights under the 14th Amendment. They asked the court to enter a declaratory judgment that refusing to allow parents to opt their kids out of the books violated the First Amendment and Maryland law. And Judge Deborah Boardman said no. She said that Maryland law only provides opt-outs for human sexuality courses, not language arts. But with regard to the constitutional claim, she said the sine qua non of a free exercise claim is coercion, and the plaintiffs have not shown the no opt-out policy likely will result in the indoctrination of their children or otherwise coerce their children to violate or change their religious beliefs. The judge quoted Parker v. Hurley, a 2008 ruling from the First Circuit dismissing a similar claim by parents who objected to their kids reading a book about a family with 2 mothers. There, the court said public schools are not obliged to shield individual students from ideas which potentially are religiously offensive, particularly when the school imposes no requirement that the student violate his or her faith during classroom instruction. Judge Boardman pointed out that when courts have found free exercise violations based on public school curricula, the challenged curricula involved more than exposure to ideas. The curricula required conduct that conflicted with students' faith, which is a really important distinction, or I guess it was until June of 2025, because until then, no court in this country had ever held that mere exposure to ideas parents disagree with violates the free exercise clause. Now, if the government wants to burden your fundamental constitutional rights, it has to satisfy what's known as strict scrutiny. That is, it has to show that it has a compelling interest in doing so and that the law in question is narrowly tailored to achieve that objective. But when a law does not touch on your fundamental rights, it only has to satisfy rational basis scrutiny, meaning it has to bear a rational relationship to a legitimate government objective. Here, Judge Boardman said the plaintiffs asserted due process rights to direct their children's upbringing by opting out of a public school curriculum that it conflicts with their religious views is not a fundamental right. And so the MCPS policy only had to satisfy rational basis scrutiny. The school board has a legitimate interest in fostering social integration and cultural inclusiveness of transgender and gender nonconforming students by ensuring all MCPS students are exposed to inclusive and representative instructional materials. And the school has a legitimate interest in preventing students who identify with characters in the storybooks from feeling stigmatized or discriminated against when other students leave the room when the books are read. And so, Judge Boardman rejected the parents' claim, and the Fourth Circuit agreed. Like the trial court, the majority on the appeals court emphasized that mere exposure to ideas is definitionally not coercive. Exposure to objectionable material alone will not ordinarily pose a burden on an individual's free exercise of religion because it lacks the requisite compulsion or pressure on an individual's religious beliefs or conduct. Instead, claims based on exposure tend to fall outside the scope of the free exercise clause because they seek to require the government to conduct its own internal affairs, here public school curriculum choices, in ways that comport with the religious beliefs of particular citizens. Now, when you're talking about hot-button legal issues, it's important to get accurate analysis from sources you can trust. The Mahmoud v. Taylor Supreme Court case was covered by about 550 sources, with 34% coming from left-leaning outlets, 26% from the right, and 40% from the center, and the differences could not be more stark. Left-leaning outlets condemned the Supreme Court's ruling as an imposition of exclusionary don't-say-gay regimes, framing parents' actions as a discriminatory backlash against LGBTQ+ inclusion and warning of a slippery slope toward widespread book bans and stigmatization. In stark contrast, right-leaning coverage hails the decision as a historic victory for parental rights and religious freedom, portraying LGBTQ+ content as ideological indoctrination from which children must be shielded. Sources on the center largely agree with the left, with a few headlines choosing to focus on the data that shows that parents who oppose sex education in schools often don't discuss it at home. Headlines and coverage vary greatly depending on the source. That's why I love today's sponsor, Ground News. The Nobel Peace Center called Ground News an excellent way to stay informed, avoid echo chambers, and expand your worldview. And I couldn't agree more. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like this one about Democrats recently launching a campaign initiative called Project 2029. Who thinks of these names? Left-leaning sources ignored it completely, or this story with coverage from right-leaning sources about how crypto thieves used Trump to steal $250,000 from MAGA supporters. Don't! Ground News is my favorite way to get the news, and as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or by clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. So click now, or we will see you in court. After losing at the Fourth Circuit, the parents in Mahmoud appealed again, and in January of 2025, the Supreme Court granted certiorari. But before we head to 1 First Street, let's spend a little time in Amish Country. In 1971, 3 Amish families challenged Wisconsin's requirement that children stay in school until age 18. They insisted on pulling their children out at 14 because their faith required them to begin farming as teens. The parents argued that forcing their children to attend school for an extra 2 years violated their First Amendment rights because it infringed on their religious observance, and the Supreme Court agreed. Chief Justice Warren Burger wrote, "The impact of the compulsory attendance law on respondents' practice of their Amish religion is not only severe but inescapable, for the Wisconsin law affirmatively compels them, under threat of criminal sanction, to perform acts undeniably at odds with fundamental tenets of their religious beliefs." Note that he said perform acts. This was not about being exposed to ideas. This was about taking Amish kids out of their communities. Chief Justice Burger said that compulsory school attendance carries with it the very real threat of undermining the Amish community and religious practice as they exist today. They must either abandon belief and be assimilated into society at large, or be forced to migrate to some other and more tolerant region. And look, This opinion is more than 50 years old. Reading it now, it comes off as pretty condescending to a religious minority. It says, a feature of old order Amish communities is their devotion to a life in harmony with nature and the soil. Public high school tends to emphasize intellectual and scientific accomplishment, self-distinction, competitiveness, worldly success, and social life with other students. Amish society emphasizes informal learning through doing, a life of goodness rather than a life of intellect, wisdom rather than technical knowledge, community welfare rather than competition, and separation from rather than integration with contemporary worldly society. It's clear that the court thought of the Amish as a sort of childlike sect of early order Christians that would die out if the government took kids off the farm during their adolescence. And I should note that Justice William Douglas wrote a powerful dissent in which he noted that high school-age children also have First Amendment rights. And by allowing parents to yank them from school after the 8th grade, you're functionally ensuring that Amish children will never have the tools to leave their communities and make their way in the modern world. He said, while the parents normally speak for the entire family, the education of the child is a matter on which the child will often have decided views. Reading the opinion, it's obvious that the Supreme Court viewed the Amish as basically a one-off. The justices said that this one specific minority's beliefs were so strong that probably few other religious groups or sects could ever meet the same standard. This was never meant to be a new tool religious minorities could use to exempt themselves from generally applicable laws. And we know that because in 1982, an Amish plaintiff argued that it violated his religious faith to pay into Social Security, and the Supreme Court unanimously rebuffed him. That opinion was also written by Chief Justice Burger. Every federal circuit that looked at this issue agreed that mere exposure to books parents object to on religious grounds does not violate the First Amendment. There was the First Circuit decision Parker v. Hurley referenced by Judge Boardman, and Moser v. Hawkins in the Sixth Circuit, and Bachman v. West High School in the 10th Circuit, and Grove v. Meade School District No. 354 in the 9th Circuit, and the 7th Circuit in Fleischfresser v. Directors of School District 200. Every single one of these courts, and a whole bunch of trial courts as well, understood that Yoder did not stand for the principle that parents have a right to assert religious objections to lessons in public schools. As the Sixth Circuit said in Moser, if parents preferred to educate their children in accordance with the dictates of their faith, they had other options. The parents in Yoder were required to send their children to some school that prepared them for life in the outside world or face official sanctions. The parents in the present case want their children to acquire all the skills required to live in modern society. They also want to have them excused from exposure to some ideas they find offensive. Tennessee offers two options to accommodate this latter desire. The plaintiff parents can either send their children to church schools or private schools, as many of them have done, or teach them at home. For more than 50 years, everyone in the country understood that religious parents don't get a veto over lessons in public schools. But now, thanks to the Supreme Court's 6 conservatives, that era is over. On April 22nd, Mahmoud v. Taylor was argued at the Supreme Court. And it was very clear from the first moments that the conservative justices were going to give the plaintiffs what they wanted.
Yeah, and one final factor that may distinguish this particular case from some of the others that you have been asked to express a view about, and you did touch on this, is the fact that it concerns sex and gender, and that the Maryland legislature itself has recognized these subjects raise special concerns and has provided for an opt-out from the health classes where these matters are discussed.
That's right. And currently in Montgomery County, you can opt out from the very same instruction during health class, but then you're required to stay during story time.
That was Justice Sam Alito in colloquy with Eric Baxter, the lawyer for the parents. The justice suggests that because the county allows parents to opt out of sex ed, it must also allow parents to opt their kids out of the inclusive curricular readings in language arts. But baked into that question is the assumption that any book with an LGBTQ plus character is a book about sex, including Pride Puppy, a book featuring a dog in a rainbow bandana who goes with his family to the Pride Parade and gets lost and eats ice cream and then gets found. That's the book that Justice Gorsuch pretended was about bondage and leather. Oh my God! Pride Puppy is an alphabet book where every page has a letter. A is for awake, animals and all. B is for breakfast, baby and ball. At the end of the book, it has like a glossary with a search and find word list for all the letters. There is no B for bondage or S for sex worker. The closest is U for underwear, because a little boy is wearing his underpants on the outside of his clothes, which I can guarantee you every kid in kindergarten noticed and laughed uproariously at, because when you're 5, that's hilarious. It's also not about sex at all, nor is the book Intersection Allies, We Make Room for All, which is about a group of girls from diverse backgrounds who stick up for each other. One is in a wheelchair. One wears a hijab. One is a black girl who goes to Black Lives Matter protests. One is Native American. One is Hispanic and works in her mother's fruiteria after school. One is a Korean girl who translates for her immigrant parents. One is a refugee, and yes, one is trans. There is no sex. There are girls hugging and saying, we're more than our origins. We all deserve care. It is wild to say that these books are teaching about sex, and so they fall under the county's rule allowing parents to opt out of sex ed. And while Justices Gorsuch and Alito were willing to play that game, Justice Barrett was not, which is not to say that she didn't work real hard to feed Baxter the lines she needed him to say to reach the result she wanted.
And so I want to talk about the public benefit analysis. So the government frames this in terms of public education as a public benefit. And your friends on the other side do too. And I'm just trying to figure out if that's the right way to think about this, because in Maryland, you're compelled to send your children to public schools, and it's a misdemeanor if you don't, and you're fined if you don't. And it's true that the statute gives you an exemption to that compulsion if you choose homeschooling or private school. And, what is it, like thorough and comparable instruction. But this isn't like a public benefit like we apply for, rubber tires for our playground, or, we apply for a license to engage in some kind of activity. There's actually a compulsion here.
Okay, stick with me for a second, because what Justice Barrett did right there was to knit together a whole bunch of recent Supreme Court jurisprudence on religious liberty. Justice Barrett is talking about rubber tires because in 2017, the Supreme Court ruled that Missouri had to allow religious schools to access public grants to resurface their playground. That case, Trinity Lutheran Church of Columbia v. Comer, was in stark contrast to generations of rulings that said it violated the separation of church and state to use public funds to support religious education. When Justice Barrett talks about a public benefit, she's bootstrapping onto the Trinity Lutheran decision, which said states couldn't discriminate against religious institutions when competing for public benefits. And the reason she did that was it got her to where she wanted to be, which was an argument that forcing religious parents to choose between sending their kids to public schools and adhering to their religious faith is an unlawful burden on the free exercise of religion. And even though it was Justice Alito who wrote the opinion for the majority, Justice Barrett's logic is what undergirded the holding. On June 25th, the Supreme Court released its opinion in Mahmoud v. Taylor. Today, we hold that the parents have shown that they are entitled to a preliminary injunction. A government burdens the religious exercise of parents when it requires them to submit their children to instruction that poses a very real threat of undermining the religious beliefs and practices that the parents wish to instill. And a government cannot condition the benefit of free public education on the parents' acceptance of such instruction. And the opinion explicitly cited Wisconsin v. Yoder in support of that conclusion. Now, no court has ever interpreted Yoder to mean that a parent has a right to opt their kid out of lessons they don't like. And yet, Justice Alito insists that everyone has always understood that teaching kids stuff that is in opposition to their religion violates their First Amendment rights. Alito relies heavily on Justice Barrett's public benefit analysis. He points to Trinity Lutheran and says public education is a public benefit and the government cannot condition its availability on parents' willingness to accept a burden on their religious exercise. It is both insulting and legally unsound to tell parents that they must abstain from public education in order to raise their children in their religious faith when alternatives can be prohibitively expensive and they already contribute to financing the public schools via tax dollars. He also tells some raging whoppers. Alito is apparently real mad about a book called Uncle Bobby's Wedding, where a little girl named Chloe is sad because her beloved gay uncle is getting married. Now, the book makes it clear that Chloe is sad because she worries that Uncle Bobby won't have time to spend with her if he starts a new family. But then Uncle Bobby and his fiancée Jamie take Chloe to the ballet and out for milkshakes and swimming and camping, and then Chloe is the happiest flower girl ever. For some reason, Justice Alito really needs to read this as Chloe harboring some deep moral objection to gay marriage. And I have a pretty good idea what that reason is. Here's a little bit from the oral argument.
The book has a clear message, and a lot of people think it's a good message, and maybe it is a good message, but it's a message that a lot of people who hold on to traditional religious beliefs don't agree with. I don't think anybody can read that and say, well, this is just telling children that there are occasions when men marry other men. Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this. Everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute, the reservation is
Can I
about...
finish, please? It has a clear moral message, and it may be a good message. It's just a message that a lot of religious people disagree with.
Did you catch Justice Alito saying that Chloe has reservations about the wedding and her mother tells her, you're not allowed to have reservations? And then Justice Sotomayor is like, wait, what? But the attorney arguing for the parents said, yeah, this is just what we warned about in Obergefell v. Hodges. That was the Supreme Court case which legalized gay marriage, in which Alito wrote a screaming dissent warning that it would be used to vilify Americans who are unwilling to assent to the new orthodoxy. And I assume that those who cling to the old beliefs will be able to whisper their thoughts in the recesses of their homes, but if they repeat those views in public, they will risk being labeled as bigots and treated as such by governments, employers, and schools. I mean, a hit dog will holler. 10 years later, Alito's still big mad about that one, and he's projecting his own feelings about gay marriage onto a fictional little girl who's worried about not getting to spend time with her uncle. In the opinion, he says, the book is coy about the precise reasons for Chloe's question, but the question is used to tee up a direct message to young readers. The book, therefore, presents a specific, if subtle, message about marriage. It asserts that two people can get married regardless of whether they are of the same or opposite sex, so long as they love each other. That's not an opinion. It is the law in each and every one of the 50 states, and it certainly doesn't infringe on anyone's religious liberty to point that out. But having used Trinity Lutheran and Masterpiece Cake Shop as a springboard to find that exposing kids to ideas their parents object to infringes on the First Amendment, Justice Alito applied strict scrutiny and determined that Montgomery County's policies could not pass constitutional muster. That was all too much for Justice Sotomayor, who wrote a furious dissent, joined by Justices Kagan and Jackson. She said, in the majority's eyes, reading aloud Uncle Bobby's Wedding is just like the compulsory high school education considered in Yoder. Reading a storybook that portrays a family as happy at the news of their gay son's engagement, the majority claims, is equivalent to a law that threatened the very survival of the Amish community in the United States. To read that sentence is to refute it. The majority's myopic attempt to resolve a major constitutional question through close textual analysis of Uncle Bobby's Wedding also reveals its failure to accept and account for a fundamental truth. LGBTQ people exist. They are part of virtually every community and workplace of any appreciable size. Eliminating books depicting LGBTQ individuals as happily accepted by their families will not eliminate student exposure to that concept, nor does the Free Exercise Clause require the government to alter its programs to insulate students from that message. She also attached the entire text of Uncle Bobby's Wedding, all 25 pages, quote, because the majority selectively excerpts the book in order to rewrite its story. In fact, this isn't the first time Justice Sotomayor has attached a picture to point out that the conservative majority is not telling the truth. In Kennedy v. Bremerton School District, Justice Gorsuch wrote for the conservative majority, which found that the First Amendment protected the right of a high school football coach who knelt at midfield after games to offer a quiet prayer of thanks. In fact, Coach Kennedy led a prayer with his players at the 50-yard line immediately after the game while families were still in the stands and both teams were still on the field. As Justice Sotomayor pointed out in Mahmoud, the conservative majority in Bremerton rejected the argument that the exposure of children to a school coach's religious prayer violated the Establishment Clause, even though hearing and watching an authority figure engage in denominational prayer with classmates at a school-sponsored event could, of course, undermine parents' efforts to instill different religious beliefs in their children. A majority of this court concluded that no cognizable coercion had occurred, and so no Establishment Clause violation adhered in the coach's conduct. Here, the court's conservatives found that a teacher reading a book about a trans girl whose mother lovingly sews her a beautiful rainbow wig amounts to religious coercion. And if Pride Puppy and Uncle Bobby's Wedding can give rise to a First Amendment claim, then anything can. Will Hindu parents be able to opt their kids out of reading books where characters eat hamburgers? Will fundamentalists be able to demand that their kids be excused from high school biology since it's based on the theory of evolution? Will parents with a sincere belief that the earth is flat be entitled to excuse their kids from seeing a globe in the classroom? Where does this all end? I guess we're going to find out pretty soon, because there's a First Amendment case coming out of the Fifth Circuit that involves a Louisiana law which mandates the display of the Ten Commandments in every classroom. We're going to find out if forcing kids to sit under a sign that says, I, the Lord, am your God, and you shall keep the Sabbath, constitutes religious coercion, or it's just like that football coach quietly praying to himself after the game. Thanks, Justice Alito.
Thank you again. Thank you again. Won't forget. Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel: transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.